Hi, my name's Chris Needham. I'm a senior caseworker. I've been with the agency for over 14 years now, and I've worked on FAS since it was first introduced back in 2011. There are some useful hints and tips throughout the slide pack, as well as some useful links that you should find helpful. I'm going to start by taking you through slide 5, which covers some general pointers on FAS. So only one fee may be claimed per activity under the FAS. This includes hearings, advocates meetings, and conferences. When different matters regarding your client are dealt with together by the court, whether they've been listed together or consecutively, then they'll be treated as a single hearing. If you represent more than one party at a hearing, then still only one fee is payable under the FAS, regardless of how many parties you represent, as it's a single activity. Slide 6 covers individual cost allocations. Counsel are allocated their own cost allocation on CCMS. We cannot pay counsel fees where the allocation is not enough to cover counsel's claim. So in these cases, we recommend you request the instructing solicitor grant you access to the case and agree a cost allocation as soon as counsel is first instructed. Counsel's allocation can be changed at any time throughout the case, so it shouldn't cause a problem. The instructing solicitor should be able to increase or reduce counsel's allocation where needed. If you're unsure of counsel's cost allocation or the amounts paid to date, you can find this on the case settlement of account screen on CCMS, and there's an example of this on slide 7. Moving along to slide 8, where a hearing is heard by a Section 9 judge in FAS proceedings, the High Court judge FAS rates will apply. Although usual exemptions from the FAS will apply, for instance, Section 9 judge fees in proceedings under the inherent jurisdiction of the High Court and international child cases remain exempt from the FAS. In those cases, it will be High Court rates outside of the FAS that will be applicable. With regards to VAT, from 1st of January 2021, VAT only applies where the work was done whilst the client has residential status in the UK. If the UK isn't their usual place of residence, then VAT shouldn't be claimed. Moving along to slide 8 now, where hearings heard by Section 9 judge in FAS proceedings, the High Court judge FAS rates will apply. Please note though, the usual exemptions to FAS will apply. For instance, Section 9 judge fees in proceedings under the inherent jurisdiction of the High Court and international child abduction cases remain exempt from the FAS. With regards to VAT, from 1st of January 2021, VAT only applies where the work was done whilst the client has residential status. If the UK is not their usual place of residence, then VAT shouldn't be claimed. If you are unsure whether that applies, then please do check with the instructing solicitor before including it in your claim. Or if you're still unsure, please contact HRMC. Fee clerks should also make regular checks with counsel to make sure counsel's VAT status is up to date and correct. Due to the pandemic, we've seen a lot of changes over the last couple of years that have impacted the way we all work. For instance, the increased use of remote hearings has changed the evidence requirements for FAS, so I thought it'd be worthwhile if we go over those now. As you'll be aware, we no longer require an advocate's attendance form. Instead, we'll accept a copy of the court order, but this needs to include the start and end times of the hearing, details of any lunch or overnight adjournments, and bolt-ons and advocate bundle fees. When you're uploading your order, it really helps caseworkers out if you can highlight any relevant recitals and directions. This makes it easier for the caseworker to pick out the necessary information. It means we're able to pay your claims quicker, and it just helps to avoid any delays due to information being missed. If the court orders don't include the level of detail set out, then we will accept alternative evidence along with a copy of the court order, such as a copy of counsel's attendance note, but the additional evidence will need to include the relevant details. For conference fees, we'll need details of the start and end time so we can be sure that it falls outside of any hearing times. For advocates' attendance meetings, where 2 meetings have already been paid, we will require a copy of the court orders listing any subsequent advocates' meetings. So you're probably just as well to provide the court order with each meeting you claim to avoid getting caught out if 2 payments have already been made. For an opinion fee, a copy of the advice is needed to support the claim. The usual rules for disbursements applies, so disbursement approaches are needed for any disbursements over £20 inclusive of that. For public transport, a copy of the ticket or receipt should be provided, whilst for mileage, a copy of counsel's attendance note or fee note will be fine to cover that. It's also worth remembering that the agency generally will not pay for local travel, so that's journeys to court that are within a 10-mile radius of the court. Moving on to slide 18. A common issue we are finding is where documents are either being uploaded against the wrong claim or where bills are being claimed against the wrong case entirely. Each time this happens, we have to investigate and report on each security breach. So this does create a lot of additional work for the agency, which impacts on the speed we're able to pay your claims. But it does also create additional work for chambers as well, as you may need to help with our investigations and will need to upload the correct document or submit the claim again under the correct certificate. So this can cause issues with counsel's accounting further down the line. To help avoid this, please ensure the bill is claimed under the correct case and that the documents relate to the correct fee being claimed. Slide 19 includes a screenshot of the case overview screen, which includes details of the case, so you can check that this is the correct case before submitting your claim, which should help to ensure fees are being claimed correctly. It's also worth noting that a copy of the current certificate should also be provided to counsel by the instructing solicitor when they're first instructed. So you can also check the certificate against the claim you're making to make sure that it's the correct case and also that the work is covered by the scope of the certificate.
Hi, I'm Tristan. I'm a caseworker based in Liverpool. I've been with the Legal Aid Agency for 11 years now, and for 8 of those years I've been processing FAS bills. And in that time I've also trained other caseworkers to pay FAS bills, and I've also acted as a lead on the fee scheme nationally. We're now going to go through some more of the specific activities within FAS and some of the common pitfalls and ways that you can avoid rejects from them. I'm going to start with interim hearings. I'm not going to go into the mechanics of how to calculate an interim hearing fee. Hopefully you should already be familiar with this. However, if you need a refresher or if you're new to the Family Advocacy Scheme, then we do have an interactive training module on the Legal Aid Learning website, and there is a link to that within your slide pack. I'm going to focus today on multi-day interim hearings. So these are interim hearings that take place over a number of days, whether that's 2, 3, 4. The cost assessment guidance confirms that interim hearings are based on the cumulative time of the hearing, and that excludes any adjournments for lunch or overnight. They should therefore be claimed on a single line based on the total hearing time. For example, if day 1 ran from 9:30 to 12:30, total of 3 hours, and day 2 was 2:30 till 4 o'clock, which is 1.5 hours, the total hearing time would be 4.5 hours, which would be 2 hearing unit 2s. This would be rather than 2 hearing unit 2s for day 1 and a extra hearing unit 2 for day 2. If you wish to check your calculation at any point, there is a FAS multi-day unit calculator in the LEA's Civil Claims Rates Calculator, and again, there is a link to that within your slide pack. This can also apply to hearings that take place across non-consecutive days as well. For instance, if you attended a hearing on Tuesday and it was adjourned, but there was no court time available on the Wednesday, so it was adjourned to, say, the Thursday or the Friday. If the court considered it to be still part of a single hearing, then this would be a multi-day interim hearing. What is important is how the court consider it, whether or not it was a separate hearing or the same hearing. For these claims, we often see that we need to reject them for more information. So it's not necessarily that they've been claimed incorrectly. However, we can't verify that the way that they've been claimed is correct. So there's a top tip there. If you're claiming multi-day interim hearings or even 2 interim hearings quite close together, it's really helpful if you can explain why you're claiming them the way you are within your bill narrative, and the caseworker can look out for that and understand your claim and confirm whether or not that's correct. A practical point: CCMS will only allow you to claim 15 hours for a hearing or 6 hearing unit 2s. If the hearing is longer, you'll need to claim your hearing across multiple lines. And you'll claim your 15 hours, 6 hearing unit 2s, and then you'll need to, on the second line, claim the remaining number of hearing units based on the cumulative time of the hearing. Again, if you're doing this, just put a note in your bill narrative explaining why you've claimed, what you've claimed, and how you've calculated it, and that should avoid any confusion and shouldn't risk your claim being returned. So we're now going to move on to final hearings. Final hearings are another area where we see quite a few incorrect claims or claims where we need to return them to ask further information. 7.127 of the Standard Civil Contract sets out the definition for a final hearing, but in summary, it must be listed as a final hearing and it must be expected to be contested. The top tip there in your slide pack is that as we need to know how the hearing was listed, it's really useful if you can include the order which lists the final hearing. As well as giving the way that the hearing was listed and making that clear, it can also provide us with context so we can see whether or not which matters were still to be concluded, and we can confirm that matters were expected to be contested as well. This is not mandatory, but it's really useful for caseworkers to have that document as well, and it reduces the chances of your claim being returned. If all issues have been agreed before you've got to court and the attendance at the final hearing is simply just to confirm the final order, then this would be considered an interim hearing because there was no expectation that that hearing would play out as a contested final hearing. The other factor to consider when deciding whether or not a final hearing fee applies is the effectiveness of the final hearing. If the contested final hearing can't go ahead, say because evidence hasn't been filed, or maybe there's been a change of circumstances, and the hearing is simply used to agree a way forward, then this would be an interim hearing, not a final hearing, because it's not been effective. For anything out of the ordinary like this, it's just really good, as I said previously, just to note within your bill narrative, and we can see the reasons why you've claimed as you have, and it'll help the caseworker understand your reasoning for that. If you have a certificate with multiple aspects, so for maybe Domestic Abuse, Children Act and Finance, and the hearing acts as a final hearing for one of those aspects, but an interim hearing for other parts, this should always be claimed as a final hearing at the relevant rates for the aspect that concluded. There are some other hearings that can also be claimed at final hearing rates. Finding of fact hearings, whether in public or private law, they are considered on a par with a final hearing for the purposes of FAS, so these can always be claimed as a final hearing fee. This is obviously on the provision that they were effective as a finding of fact and it went ahead as a finding of fact hearing. But as long as it went ahead as a finding of fact hearing, then a final hearing fee applies. In public law, it's also possible to claim issues resolution hearings as a final hearing rate if it concludes the matter and there are no further hearings that take place on that matter. So the court order should be uploaded in these instances just to show that it did conclude and it was listed as an issues resolution hearing. It must conclude the case as a whole as well. So if there are multiple children involved and a final order is made for one of the children, but there are other children where the matter is listed as a final hearing to make the final determination for them, this would be an interim hearing because it has not concluded the matter as a whole and there are further hearings listed. This only applies for an IRH in public law proceedings. Any other hearing would not be a final hearing and should be claimed as interim. This is probably the most common reason for rejects when it comes to final hearings, so I can't emphasize this enough. If the case concludes at a dispute resolutions appointment, usually in private law, or a case management hearing, or sometimes hearings that are listed as a CMH/EFH, so case management hearing / early final hearing, any of these, they're not listed as final contested hearings and they're not listed as issues resolution hearings within public law, then these have to be claimed as interim hearings because there is no provision within the contract to pay them as final hearing fee. We're now going to move on to look at advocates meetings, and the key points for advocates meetings are that they can only be claimed in public law proceedings and they must be ordered by the court. If the advocates agree between themselves to a meeting, but it's not been ordered by the court, then this cannot be claimed as an advocates meeting fee. If the court have agreed the advocates meeting via email, this is absolutely fine. Just include a copy of that email from the court showing that it was approved by the court. Occasionally, the court will also put in an order that says that an advocates meeting should take place before every future hearing. This would be fine as long as the advocates meetings that you're claiming are after that order has been made, or the order clearly states that it applies to advocates meetings that have already taken place. If you have an order like this, just make sure you upload it with your claim and also refer to it in your bill narrative so that the caseworker knows where to look for confirmation of the advocates meeting. We would usually expect 2 advocates meetings to be claimed in line with the public law outline. However, there is no limit to the number of advocates meetings. We would just ask that it's just a requirement that after the second advocates meeting, we would always require the court order as evidence for this. The top tip there in the slides is always upload this court order, even if you believe that you're claiming for the first or second advocates meeting. You may find that another advocate has already claimed for one, and if you've already uploaded the order, it just avoids your claim being rejected to ask for this. The rate of an advocates meeting relies on the level of judge presiding over the related hearing. So this is the hearing which will follow the advocates meeting. If you're claiming your advocates meeting with the interim hearing, then the evidence of the level of judge will already be there. However, if you're claiming just the advocates meeting on its own, then we would require some sort of evidence to show the level of judge at that related hearing. whether that's the court order from the hearing or an attendance note, something like that. The last point on advocates meetings is that the only bolt-on that can be claimed with an advocates meeting is the exceptional travel bolt-on. So where you're travelling 25 miles one way to the court. Any other bolt-on cannot be claimed with an advocates meeting. And if it has been claimed, then we would need to reject the claim for you to remove that.